Yeah, I'm glad you're back, and I'm glad not a single animal tried to kill you that I know of.
Oh, well, no, people are the only ones who try to kill me. It's mostly just Rosalind, but
just me.
You know, yeah.
We can get up to no good. It's all right.
All right, but you are just in time because we have been talking about the Delphi case for an hour, but now I know you already listened to this, but I listened to parts of it on your show, and then I saved myself for this.
Cool.
This is Laura Owens' mother and father in their second attempt of bankruptcy, which doesn't go well. Now, their previous Chapter 7 bankruptcy was dismissed because they refused to follow the guidelines and submit documents. So their house was about to be foreclosed. And they did a Chapter 13 chess move, which forced the auction to be cancelled. And we listened to part 1 last week, and here they are back. And what I absolutely enjoy about this, and I bet she actually asked to be the trustee over this case, is this is the same trustee as in the Laura Owens bankruptcy. And she verbally killed Laura and caught her in so many lies that even Laura, at the end of it, kept her mouth shut. But not before she incriminated herself several times.
With more crimes. Mm-hmm.
With more crimes. So, this is her parents, who are now going to try to explain why they should be able to voluntarily dismiss their Chapter 13 bankruptcy case without prejudice. And the trustee is of a different opinion. Let's see here. Let's get... So this is sound only.
In the case 26-05-144, Elizabeth Naylor and Ronald Owens.
Good afternoon. I'll take the appearances in the Naylor and Owens matter. Let's first start with the debtors.
Yes, I am Elizabeth Naylor Owens, appearing pro se, along with my husband, Ronald Stephen Owens, also pro se.
Thank you.
And I'm Ronald Owens.
All right. Thank you. Good afternoon.
Yeah.
Good afternoon.
Good afternoon.
I'll take other appearances, please.
Oh, I should have tried to edit this beforehand, because the attorneys and the judge are extremely silent, while at least Jan and Ron knows how to speak into a fucking microphone. There's an illness amongst the lawyers and judges in the United States. They can't use a microphone if their life depended on it.
It's true.
Nope. I think they do it on purpose.
Yeah. Almost.
Please. Oh, Ms. Jamo, you're muted.
Sorry about that. Good afternoon, Your Honor. Jennifer Giamo on behalf of the United States trustee.
Jennifer Giaomi. Oh, she's a star. And she's very, very scary. I would not want her on opposing side on one of my cases, because some are receptive of emotional arguments. She's not. At all.
Oh. Thank you. Good afternoon. All right. Any other appearances? Nope. All right. Let's go ahead and get started. This was the time set for the court to consider on a continued basis the debtor's emergency motion to extend the automatic stay. Since that last hearing, let me just roll back and say that at the last hearing, the court did temporarily extend the stay under 105 and 362 and directed that the debtors complete their filings in this case. There were schedules and statements filed, but they were replete with error. And also the debtors need to provide information to the Office of the U.S. Trustee. That date has come and gone, and the last I checked, there were no papers on the docket to satisfy those requirements. I did, however, see that the debtors filed a motion to dismiss this case. They lodged an order of dismissal, and the Office of the U.S. Trustee filed a limited objection. I do see from the docket that the trustee's office has continued the debtors' 341 meeting, so it sounds like that's not yet concluded. I'll tell the parties, with respect to the motion to dismiss the case filed at 57, it was filed along with, just as I indicated, a notice of lodging order, but that would be procedurally incorrect. In a Chapter 11 case, motions to dismiss must be noticed out to the master mailing list. I believe it's a 21-day notice. It's unlike a Chapter 13 where a debtor has the right to dismiss their case at any time. Chapter 11 doesn't work like that. So I did want to, at the first instance, Ms. Naylor and Mr. Owens, tell you that the court has taken no action on your motion to dismiss because you have not noticed that out, I don't believe, to the bar, or I'm sorry, to your creditors, nor have you asked for a hearing or undertaken any other procedures that would allow the court to take action on your motion.
Yeah, so basically, they just asked, yeah, can we dismiss it? Yeah, but you kind of need to check with the people you owe millions of dollars to.
Isn't this the second time they've tried to dismiss some ad hoc bankruptcy?
Now, last time they had a lawyer. Now they are trying to blame that lawyer for not knowing what they're supposed to do in this case.
That almost would make sense.
I wonder why they couldn't hire him again.
It really makes you think.
Is that why they talked to like 21 lawyers? Because they didn't hire him again? Or would he not take their case? And that's why they went to 21 lawyers. This is just...
Yeah.
Every time you think that this case cannot get to a new level of what the hell, here we are.
Yeah. It's the family that keeps giving content.
That's what she said. I couldn't help myself. It was dumb.
Oh, sorry.
I said I couldn't help myself. It was dumb. But, sick drink thin, and what are you going to do?
From the court's perspective, that's where we are procedurally. I understand that the debtors no longer wish to be in this bankruptcy case. The U.S. trustee has asked that any dismissal be with prejudice and has a bar to filing for the next year. Often in these circumstances, the parties come to an agreement. And I guess that is my first question after that long introduction is, have the parties come to an agreement?
Yes, my understanding is that we have.
Okay, Ms. Jamo, do you want to tell me about that?
Yes, Your Honor. So I spoke with Ms. Owens, and then I did call the case in the 341 at the time of the 341 meeting, and we have it on the record that both Mr. and Mrs. Owens, both debtors, agree that the case will be dismissed provided that they are barred from refiling in any bankruptcy court for a period of 1 year. I have sent, just today, I sent to the debtors a proposed stipulated order of dismissal. And then I was going to ask Your Honor at this hearing if we could set the matter and have the debtors notice out the dismissal motion. And then hopefully if nobody responds, we can vacate the hearing and upload the stipulated order of dismissal.
All right, from a procedural perspective, that makes sense to court. The question I have, though, is at the last hearing, I heard a lot of information about ponies and GoFundMe accounts and other potentially non-disclosed assets, which leads the court to believe that there could potentially be non-exempt assets that could be recovered should this case be converted to a Chapter 7. And a Chapter 7 trustee had the opportunity to investigate and to potentially recover and liquidate those assets for the benefit of creditors.
Yeah. So this is called a clawback. they already knew they were in debt, deeply in debt, when they started the GoFundMe, which money they have used to something. Well, that's if you are in debt and you come across a lot of money, even if it's a GoFundMe with a specific purpose, if you're heavily in debt, any income should go to the debt. And if you spend the money and say, oh, sorry, I don't have the money anymore. Oh, really? Where did it go? Because we are going to take that back.
Yeah. Aren't horses a really expensive sport too? I guess I don't understand living like you're still wealthy and then trying to, file for bankruptcy.
Yeah.
Gotta keep up appearances.
Yeah.
Gotta make it seem like everybody.
And here's the thing.
I never cared about those.
Yeah, but that's the thing. They are not poor. They have a combined over $20,000 a month in pension and retirement.
Right.
A month. $240,000 a year. And they
What
are
did they
still
say
broke.
was their monthly outgoing?
Well, they claim they have outgo mortgage, like $12,000, and other debts. And
that's
other,
right.
yeah.
They're upside down on their mortgage. That's what the problem is. Yeah.
Yeah, and so, but they haven't paid their mortgage since.
Yeah, Meghan Markle's school of mortgage fraud.
Yeah. So, which means that debt has risen with like 300,000 since since they stopped paying. So where did that money go? Because so they are way over their head, which means that, your house is getting sold now.
So this lawyer that they probably paid with the GoFundMe, that first lawyer that they probably paid with the GoFundMe, is he now going to have to become a creditor? They're going to take the money back? Is that what's going to happen?
They usually do make them creditors, right?
Yeah, but he you can he can argue a good faith acceptance of that money because he didn't realize, at least Laura's criminal defense attorney.
Yeah, not the current one, but the one before, I guess, would line up with the timing. Josh Goldsred.
Yeah, but the current one
right
should have done the due diligence.
The looter.
So that could be that could be subject to a clawback, but not the previous one. So they much.
Okay.
But generally, lawyers are, for some reason, judges don't like clawing back money from lawyers. I don't know why. It's weird, isn't it? But if they do, well, then they have a new creditor who might not have the discount anymore.
Discount. Coupons.
So.
And similarly, if there has been a fraud upon the court or otherwise, whether the debtors could be denied a discharge, and that might be something that a Chapter 7 trustee would look into. And I didn't see that that wasn't addressed in any of the parties' papers, and I don't know if there's been a conversation. Ms. Jarmo, I don't know if you've had an opportunity to undertake that analysis, but it seems to the court that it would be remiss to not at least explore whether it makes sense in this case to not just dismiss the Chapter 11, but to consider whether it should be converted to Chapter 7, where a Chapter 7 trustee can administer whatever assets might exist and potentially pursue fraudulent conveyances and transfers. And I guess what concerned me was if we had this large sum of money within the last year for the GoFundMe account, that seems to be an asset that could be potentially recovered for the benefit of creditors. If it was paid to one particular creditor, say the mortgage company, that money should be recovered for the benefit of all the other creditors. And so these are the thoughts that came to me as I read the parties' papers. I don't know if anyone would like to address that.
I could address that, but if the debtors want to speak first, I'll wait my turn.
No, go ahead and address it if you'd like to.
Okay. So yes, Your Honor, we absolutely thought of those things, and I appreciate Your Honor bringing them up because those are very crucial issues. In fact, my initial analysis of this case, I saw that the writing on the wall was going to be likely a motion to convert or dismiss and likely conversion. However, regarding some of the assets, I know that there was discussion about some horses. The debtors have a daughter, Laura Owens, who had previously filed a Chapter 7 case. And that case has since been dismissed, but I spoke at length with the attorney, Terry Dave, the attorney for the Chapter 7 trustee in that case. And my understanding was that there was not any feeling that there were really going to be collectible assets that were worthwhile to pursue for the benefit of creditors. And I know that it was the same companies that are owned by the debtors and that were disclosed in this case. Now, the GoFundMe, no, that would have required further investigation on my part, and it was something I was going to pursue in the Section 341 meeting. I think that this outcome is probably the best right now. There's no other creditors, not even the banks have come in and said anything, which I was a little bit surprised about. But I do think that if the case is dismissed, provided that they do not file for a year, then these financial matters will sort themselves out. So it's the U.S. trustee's position that this is a good outcome, provided that there be a bar to refiling. If the court is not inclined to grant it, then absolutely we would take up the 341 again. And I would say that in all likelihood, we would be back before Your Honor, asking for a conversion.
All right. Thank you, Ms. Jaimo. And I guess the way to maybe tease that out a little bit is to go ahead and get that motion to dismiss noticed out to the creditors and others. I guess what concerned me was just looking at the docket, there was the motion to extend the automatic stay, which was opposed by the secured creditor. And then curiously, the secured creditor withdrew that opposition, which suggests to me that perhaps funds were accumulated and paid to the secured creditor, which is why they withdrew their objection. And if so, then that would be a classic preferential transfer that would be an asset to be recovered for the benefit of all other creditors. And so I think that's something we should get some better understanding on before the next hearing. So that's what the court's thinking. And so again, I'm inclined to give you an opportunity to notice out that motion, because I'm not going to grant it here today. Your creditors need to have the opportunity to understand that is what you're looking for. But what do you want to tell me, Ms. Naylor?
I was going to tell you that no funds have been transferred. And with regard to the GoFundMe, which I'm sure you were notified by the online smear campaign that has gone against us.
That's one way to sound like absolutely schizophrenic. When you're
wow.
Online smear campaign, aka facts.
Like she sounds like she's off her meds or something is the problem. And like all you had to do was just say like nothing. All you had to do was say nothing there.
Yes.
But these people can't say nothing. Right?
No, I mean, there are some people. I mean, there's joy. Some people have the right. People have the right to remain silent, and some doesn't have the ability.
Right.
And Jan, as her daughter, can't for the life of them shut the fuck up.
It's so hilarious. She's like, I'm sure you're aware there are Facebook groups, there are people making fun of me,
just smearing my name, besmirching us.
And the judge is like, no, but I did stay at a Hotel 6 last night, so I'm going to judge this case.
Oh, brother.
So let me just interrupt you to say that the court only reviews what is filed with the court. So I know you referenced an online smear campaign before. I really have no idea what you're talking about. All I have is what has been filed on the docket and what people tell me in open court. I do not independently go out, and it would be unethical for this judge or any judge to go out and do background research on people and learn about them. So just
that's what the trustee does.
Yeah. Or the lawyers in a civil case are the one doing the research and then present it to a judge. not some whack job sending an email with a false timestamp. Like in the Karen Reed case, Michael Proctor's medical records were revealed online. No, they fucking weren't. And Judge Uncle Bev reamed all the lawyers out.
Uncle Bev.
Uncle Bev. Yeah.
Okay.
Can we just start calling people Gilday now? Is that the next judge that sucks?
Yeah, I mean, he basically confirmed our suspicion that Michael Proctor is mentally ill and is in a loony bin because of his actions in that hearing, where he confirmed, I saw this, and it striking resemblance to what was in the medical in the impounded material. And everybody said, thank you, Judge, for confirming it for us. And but the impounded material has not been disclosed.
But thanks for letting us know. Like, it's almost like the person who tweeted that out set you up.
I didn't know being a douche was a medical condition. I mean,
it can be.
Godspeed, Proctor. I hope the cranial extraction from your other region goes well. I would suggest lidocaine.
No. I have thoughts being 6 years in a hospital. I have thoughts, and there's no lidocaine involved. But that's why I'm mean.
Can you be cured of the isms and phobias?
There's only one solution for a person like that, and I can't say it on YouTube.
No.
I saw a puppy.
That was honey.
Aww.
Oh, honey booger.
I thought I saw a puppy. Aw. Imagine having a pet that likes cuddles.
Oh, yeah. She's just huge, though. It's just can kind of take over the space.
Yeah. Mr. Jingles is not the cuddly type.
She's a little too kissy face.
Aw.
I love her.
Well, if you're not there all the time, it's only affectionate. But if you're there all the time, yeah, get away from me. Stop putting that thing in my face. That's what she said. Let's continue.
Not Laura Owens.
Just so you know, that's the way the court will operate.
I'm not suggesting that. I know that the smear campaign people have said online that they have sent information to your office. So I don't know whether you've received.
Nobody has sent stuff to this judge.
I don't recall hearing anyone say that.
No.
So plus smear campaign people is a pretty wide population based on her assessment of what smear campaign is. So who exactly are you speaking about?
Yeah, it's more everybody but them. And nobody. I mean, this is just tragicomic. It's gallows humor. Nobody cares enough to send them the court stuff.
No one's gonna waste the postage.
I mean, but also, wouldn't the the judge's assistants and all of that get it first and intercept it and say like, this is
garbage. Yeah,
it's garbage. We can't look at it.
Other than entertainment purposes, nobody really gives a shit about you guys.
Yeah,
no one does.
But now I kind of want to send a question to the court. Hey, can we have that material?
Yes. Is it in the public record? Because I'd like to see the smear campaign.
Yeah.
And smear's a weird word to use with her case specifically.
Yeah, I mean, they kind of put themselves in that position. I mean, I feel sort of sorry for Ron because he really had everything set for him. He was successful. He was a multi-millionaire. And now, okay, he had a gambling habit and he has his illnesses, but they still have $20,000 a month. Move to a condo, for fuck's sake.
Exactly. Why not live in a condo?
I mean-
You're elderly. Like, enjoy the
Yeah.
fact that you don't have to have a yard and all of that, and just hang out
Yeah.
at the pool.
Yeah.
Most people would be over the moon to have $20K a month.
Yeah. They could rent a condo for $5,000 a month, and you get a lot of condo for $5,000 a month, and have a more or less live-in nurse for another $4,000 a month.
Yeah, I'm shocked that he doesn't have in-home health care or things like that.
No, but Jan is
He
his
could, technically
full-time
could.
provider because
could
she's
get
so
it.
nurturing.
Oh, her and Dr. Mengele.
Oh, and they claimed, you can't take the house away from us. It is adjusted to his needs. There's no adjustment to that fucking house. There's nothing in that house that is. I mean, he has his walker and he has his chair and he has
the black chair.
I mean, they could just move over here to the villages. I mean, they got plenty of old person controversy down here to satisfy their need for drama, and also you wouldn't have to pay as much every month.
Yeah.
Also, most assisted livings do not care that you are broke because they will more than happy to apply for Medicaid or long-term care and take government money to house you. So, because they drain all your assets anyway, so they can apply to Medicaid. So, it's kind of a win-win. You don't have anything. They don't charge anything.
Yeah. For $10,000 a month, they could live a comfortable life, which means they could pay off their debt with $10,000 a month. But no, because they have an adult autistic daughter living at home.
Yeah, okay. The autism diagnosis by blog is still an interesting thing. The fact that they're missing the legal documents now is amazing to me.
Adult onset autism.
Adult
I know a doctor who runs an ABA clinic. I really want to talk to her about this one day and see what she thinks. Because she works with autistic kids. That she started a business to help autistic kids. And I really want to sit down and talk to her one day and be like, here's the situation. I need your opinion from a medical doctor's perspective because I don't get it.
Yeah. She's also the world's oldest child prodigy. I mean, what are we talking about here?
It's true.
Oh, shit.
Oh.
These people give you a headache.
He appeared to have a care assistant with him. Okay. He might have.
It just depends. You can have like weekly visits. You can have daily visits. You can have live-in. I mean, live-in's probably a little bit more expensive.
The volunteer. I mean, they claim they are broke, so they might have applied for a volunteer.
But they have private insurance too. So that's what I don't understand is it's an option.
Yeah. If they paid it.
I think he gets it as part of his pension with the. I guess he's SAG too, right? They're both SAG.
Then Ron, with all due respect for
or
your
whatever the radio
marriage,
equivalent is,
divorce the bitch and go live happily ever after the remaining 9 months. I mean, seriously.
Remaining 9 months.
Run.
Ouch. Odd choice of timing.
I didn't even realize that.
Well, and here's the thing. I don't know. I haven't paid much attention to what she's getting, but you get paid to be a caregiver. So you can deny all the other services that he's able to get. And you say, I'm his caregiver. You apply with your state. I don't know how Arizona does it, but you can get money in order to be someone's caregiver, which is like, it is helpful in some ways, but you get really shitty caregivers sometimes because you get family members that are greedy and just want money and don't really care. So
I'm not sure if they would qualify for that perk though, with the amount of money they have coming in. It's a lot.
Good point. That's what I don't know how Arizona does it, but in most states, in some states there's no income restriction because you're caring for a family member. So you're giving up part of your income that you would get if you were working to take care of someone.
Right.
So, but I don't know how Arizona does it. So I haven't looked it up, but I probably should.
Received it or not, and I know that they also sent it to the U.S. Trustee's office. But with regard to the GoFundMe, as I mentioned before, it was started in 2024, and all of the funds from that were exhausted by, I mean, with the exception of maybe I don't know, a couple $100 or something like that, were all completely exhausted by the time that we filed Chapter 13 last August. That money.
On what?
What?
Yeah. Clarify.
Yeah, please clarify. File it in a document, which you, because remember, Jan, you should have disclosed this. The 3 years of income. Remember, Jan, what did you make the past 3 years as income? GoFundMe counts as income.
Was used, and in fact, the GoFundMe was started in part to try to prevent this bankruptcy and the Chapter 13 that we'd had to file last August.
Really? I thought the GoFundMe was to defend your daughter.
Yeah, that's what I thought
No,
it
the
was.
GoFundMe was to pay his medical bills, right?
Oh,
if you actually look at the GoFundMe, it is for Ron's hardship based on his medical bills and their financial issues related to that.
Oh,
yeah,
okay.
Which was in question because of the fact that he has such good coverage.
Right, so. And they listed their medical expenses as something insanely low in their bankruptcy documents. And I was like, that doesn't make any sense.
I could see there being very expensive medications if he has to take a name brand or something like that, or there's a new Parkinson's med. I could see that being very expensive and not covered.
Yeah. Right.
But
you got to prove that
show on the chart.
Yeah. Well, that's the other thing. You have to prove everything, and they don't seem to want to do this. So
what was it, hundreds of dollars or something in medical expenses, and they're asking for $140,000 supplemental help from people on the outside, even though they already get $20,000 a month, and he has health insurance. Like, there's something here that's not adding up, obviously.
Yeah.
Right.
And
yeah.
most providers,
I don't think they disclosed their income in the GoFundMe.
No. Yeah, they did not.
I wonder why.
Somehow I don't think it would have been so successful if they disclosed, yeah, we have $20,000 plus a month in pension and retirement. Please send us money. You who only make like $30,000-$40,000 a year.
Yeah. Right.
People who are on a fixed income, send us money, because our fixed income that we're on is 7 times yours, but send us money because we're broke.
Yeah.
To try to get the funds. And at that point, some of the funds from the GoFundMe.
Wait a minute. You said it was started in 2024. You didn't file for bankruptcy until... Now, you might have seen that you were heading that way. But, I mean, all you had to do was say, Laura, get a fucking job.
Heaven forbid you get a
but
job.
Apparently that is too much to ask.
Mm-hmm.
Let's see here.
You can get a job.
I would just for one day like to see, like, be a fly on the wall. What is it that Laura does all day?
I would.
Just for one day. That's all I could tolerate.
She
just Google herself all day.
Google searches men and tries to come up with stories on how she's going to trap the next one because she's running out of money.
Yeah, because now all of a sudden Daddy doesn't have money anymore. It must be so hard on Laura. Thoughts and prayers.
What will a
Bless her precious
nearly
little heart.
40-year-old woman do? She might actually have to get a job.
Yeah. She had to admit in her bankruptcy court that she had never had a job in 35 years. And that, but you say here in this deposition, and you on Instagram or on LinkedIn that you are the CEO of this company. Well, I'm not.
I loved her LinkedIn profile. It's my favorite. She's the greatest overachiever ever.
And presented it on the company website as founder and CEO.
Mm-hmm.
But all of a sudden, no, I was kind of a helper and a manager. I used these words interactively.
Okay, Amber Heard.
Yeah, hello, Laura. Hello, Amber Heard.
Is putting that you're the CEO of a company on your LinkedIn like the equivalent of putting pictures that were like from 20 years ago on a dating profile? Like it's you technically, but it's not really you.
Professional catfishing.
Yeah.
Yes.
Yeah.
There we go. Better term for it.
If you make yourself out as being successful, you attract successful people. And then you pretend to be pregnant with twins when they discover you're a fucking lunatic.
But she's only pregnant by The Bachelor. Oh my God.
Oh, I can't wait for the criminal case. I can't wait for the criminal case. And I bet the defense will try, no, we don't need this live streamed. And the rest of the world says, oh, yes, you do.
Yes.
This is of public interest to see this serial pregnancy scammer try to explain herself in court.
It's a good question, Malin. Good question.
How did
she get a new car?
Oh, yeah. I've heard about this. I haven't seen it, but apparently she was seen in another car.
Manifesting success. Chat's cracking me up. Your life coach.
Does Lauren know about the Karen Reed case? No, but I do believe since she's in Arizona, the comparisons with Jodi Arias are there.
Karen, I don't even know much about Karen Reed. And the thing is, like, I know how the criminal trial ended and all that, and I know there's a lot going on with that, but like, I don't even know anything about that case, honestly, because I wasn't around when all that started, and then I just kind of saw it on the news when it was being covered in the trial.
Right.
Yeah. Basically, the feds got involved. The feds hired experts, and the experts concluded that physics say the car did not hit John, and John was not hit by a car.
Okay.
It's the basic laws of physics.
Gotcha.
Yeah.
Apparently, John defied physics.
Missing dog, filled in pool, replaced carpet. Nobody came outside of the house with everybody there from the law enforcement seeing a dead person in their front yard. So they just stayed inside, had cocoa or whatever.
It's their cell phones.
It's a deeper rabbit hole than this one. Let's just say.
Oh, yeah.
But you still have people online which are relatives of the house defendants with 10 accounts each who absolutely did it. Okay, explain physics. Well, she reversed 24 miles an hour during a snowstorm and hit him. Yeah, but in that angle, she would have hit the fucking house as well. Yeah, it's a lot of stupid going on. And here's the thing, Laura Owens, more people... You're more...
Nick, you okay?
In the Laura Owens case, there's not a content creator, to my knowledge, on your side. Right. At least in the Karen Reed case, there are content creators claiming she did it, including but not limited to what's the name, Carpenter, who was fired from Court TV because she became a bit too much of a lunatic, which is quite interesting.
She a YouTuber yet?
Probably.
Don't know. I haven't bothered looking into it.
Okay.
Let me say that. Which is quite telling because even in the Delphi case, you have her, what's her face, who is still a guest on Vinny's.
Oh, yeah.
I can see her face. I just can't.
Yeah.
Julie Grant? That's.
Is that her? No.
I'm sorry, Yuli Grant. Sorry, couldn't help it.
Yeah. Everybody calls this the TBDS, Total Boy Derangement Syndrome.
Mm-hmm.
All right, but that's a different case. We will talk about Karen Reed case later.
Were used to pay mortgage at that point, like I say, before we filed the Chapter 13. So it was all virtually exhausted by.
Okay, where's the paperwork then? Jan. Where's the paperwork? You're supposed to have submitted this voluntarily. Instead, you're getting it dragged out of you.
I would venture to say by May of 2025. So that's why it wasn't. We didn't mention it in the Chapter 13 filing because it didn't exist. It had been used.
3 years of income, Jan? Disclose 3 years of income. It's not that hard.
No.
It is when you have to be honest.
Oh, yeah. Those technicalities.
Well, transfers that are made shortly before the bankruptcy filing do have to be disclosed. That it's problematic if you did not disclose the use of those funds. I'm going to order and direct that you provide the records concerning that that particular issue to Ms. Jaimo so that she has an understanding as to the financial circumstances immediately preceding your prior case and this case, so that her office and the court has a full understanding of the circumstances before the case is dismissed. Because the court does need to make a determination whether best interest of your creditors would require conversion rather than dismissal. But at this moment, the court will not make any such determination. And again, the only information I have is that which is filed with the court and that it appears on the court docket. I don't believe I have any communications on the court docket from other parties, only the filings that I've seen from you and the U.S. Trustee's Office and the creditor. I believe that's all I've seen on the docket. Okay. Okay. Do you have any questions about the information I'm directing you to turn over to Ms. Jaimo?
If you could just outline it again so that I can take a note on it.
I'm really asking for a full accounting of the GoFundMe account, the monies that were received and the monies that were spent and how they were spent. And so, the whole typical information, what did you get? When did you get it? What did you do with it? Where are your receipts?
Okay.
Okay. The who, what, when, where, why, and how. Okay.
Okay. But again, that was all prior to the Chapter 13, that if we'd had those funds, we wouldn't have needed to file Chapter 13 or Chapter 11.
Okay. Well, I hear what you're saying. Some transfers can be recovered despite the passage of time. This case was filed on May 22nd of 2026, and it could be that if there were funds that were transferred in a particular period, they would be of interest to the U.S. Trustee's Office. Okay. And let me ask Ms. Jaimo whether there are other information. I know that I had directed you to email to Ms. Jaimo the information required for the initial debtor interview as well as the 341. And I don't know if that's occurred. I believe that that should happen before this case is dismissed. I think we should have a fulsome understanding of your financial circumstances. So I'm going to order and direct that you provide that information to Ms. Jamo's office. Everything that you're supposed to be providing, you need to provide. So whatever that office is asked for, I'm ordering and directing you to cooperate and to provide that to her.
Your Honor, we were unable to do that. I had presumed that we would be able to get counsel to help us. This was never my intention to file pro se, and I'm very aware of the fact that Chapter 11 is a very exhaustive chapter to go into as a pro se litigant, and that was not our intent. Our intent was to be able to get counsel, and we have been unable to obtain counsel.
Well,
and
you know your financial.
I wonder why.
With what money, though? Like, with what money were you expecting to obtain counsel?
Yeah, I thought they
with
were.
what money, and with this history as, Mr. and Mrs. Attorney, can we hire you because we don't want our house foreclosed? So we are going to file this now to force a stay. No.
No.
Hey, Nick, I'm going to have to skedaddle. So I'm going to bop.
too.
I'm going to bop. That's okay. I've got a potato salad that needs to be made.
Oh, okay. Yeah, we will. I will go on for a while more, but so you are welcome back. You have the link.
I appreciate it. Thank you so much, and goodbye, all.
Bye. I'm heading over to Shizzy's, but I'll still be on the internet. Bye, you guys.
See ya. Everybody's leaving me. Oh. All right, let's continue here.
Circumstances best, and so you should be able to reconstruct that information and gather those records to provide it to Ms. Giamo.
But Your Honor, I'm unable to without adequate counsel.
No, you get these funds you got to your bank or Ron's bank, and then you paid stuff. Get those receipts from your bank. But that is apparently a very, very hard thing to do without counsel.
I feel like she's never done anything independently in her life. She's always had someone else do stuff for her, and that's why Laura ended up the way she ended up, because that's how she grew up, always having somebody else do things for you. And now there's nobody to do things for you, and she doesn't know what to do. Her brain is buffering.
Yeah. That's not. No.
If I had been able to do that on my own, we would have continued this on our own.
Right, but you filed this case. You filed a Chapter 11 bankruptcy case. You have not yet paid the full filing fee. And once you're under the jurisdiction of this court, you have to abide by the United States Bankruptcy Code and its rules and requirements. And I'll tell you, one of the most important things about the Bankruptcy Code is it requires absolute transparency. And that's the concern of the court, is that the schedules and statements here compared to the prior schedule statements seem to indicate a lack of transparency. And so as a participant in the system, you have certain obligations, and I'm directing you to fulfill those obligations. And when we return for the next hearing, Ms. Jamo can give me an update and let me know what she's been able to learn. And it could be that a dismissal is still the recommendation and will be the course of action. But it's not appropriate to file bankruptcy and park in bankruptcy and obtain the protections of bankruptcy and yet not fulfill the obligations. And so again, that is your obligation. You filed this case. You undertook these duties and responsibilities, and now I'm directing you to cooperate. All right, Ms. Jamo, anything you need to add?
I just want for clarification, Your Honor. So the noticing of the hearing on the motion to dismiss, at which we'll discuss what happens in the interim, is that something that the court is going to notice out, or are the debtors required to do that?
The debtor should be noticing it as a Chapter 11 case. Let me ask the court deputy if there's any provision for the Chapter 11. Generally, in Chapter 11, those debtors undertake the noticing. Do
They do, Judge, but we can if we need to.
Okay.
Yeah.
Take a look at the master mailing. Let's see how big it is. We're going to take a look at the master mailing list. Just a moment.
Doesn't give me a number, but I would.
Hey guys, unfortunately, I gotta run.
The court will go ahead and notice out the hearing on the motion to.
Oh,
Good to see you, Lauren.
Yeah, you
good
too.
to see you. Thanks for joining in. And as I said earlier, I'm going for a while. And if I'm still on, you're welcome back.
Yeah, I'm probably gonna go back over to my parents' house. So I'm not sure I'm not be over there, like how long I'm gonna be over there. But I will next time, anytime you want. Of course, I'll be here earlier next time. I promise. So
No worries. No worries.
all right, thanks, guys.
Thank you.
Bye.
Bye.
Hi, Lauren. I feel bad. I didn't
Dismiss.
realize that I was muted when Rosalind and Mo left, and I said goodbye to them, and then realized that I was muted. I was like, I was like, that was rude. And that's what I get for drinking.
Oh, it's fine.
I
I'm
was
here.
like,
I'm
I
almost
looked and
out
I
of
was
my
like-
five. I'm almost out of my 5.6% beer, and now I have to go into my 9 point something.
This is one of those situations where I wanted to ask you if it was possible to send booze through the computer.
It's
Because-
it could be an untapped resource.
Because some of this, her responses to some of these questions, like I have had 6 drinks, so I am a little woo. However, I feel like I could go in front of this judge right now and have a better conversation and have more coherent answers than this. She's acting like she's never written a check, or she's never like gone to a bank, or she's never looked at a bank statement in her entire life. It's like, how did you manage before you got married? Like,
She probably didn't. She was looking for a wealthy husband.
I mean, we
And
would all
found
like a
one.
wealthy husband, but
I mean, she is
still
20
learning
years
to
younger. She is like 20 years younger than Ron. So he was already mid-successful career when she showed up about, I would guess, 37 years ago.
Dan loves to act dumb. I'm not really sure that that's an act.
Isn't she an award-winning journalist? Yeah. Some awards you pay for. Let's just say that. It's like the lawyer of the year or best lawyer in this state. Yeah,
Okay,
you pay for it.
And okay, so take this one with a grain of salt. But I remember back in the day when Megan was doing her podcast, that short time when she started a podcast, she, in her intro that IT Goatee Brad read for her, that she said she was an award-winning journalist. And when you asked her about it, she made fun of it. Like, yeah. So it's like you can be an award-winning anything if you spin it right.
Yep.
I mean, I know that she's an author because I have one of her books on my bookshelf, but like the award-winning journalist, even Megan will make fun of, but at least back in the day, I don't know about now, but back in the day, she made fun of that. So you can spin things depending on
absolutely
what the award was. Doesn't have to be a major award. Could be like, you know,
mom of the year award. Just because you can connect the two, as in I have won an award and I am a
Oh my God, Swamp Bear, I just have to respond to this comment real quick. Resting, listening to this, and trying to cope with a leg and ab day yesterday that I overdid. I went to the gym this morning, and stamina on Fridays is always partner workouts. Well, I walked into the gym, and the gym owner was like, "How hard do you want to work today?" I'm like, "What do you mean?" "Well, this person needs a partner." This person went to Switzerland like a week and a half ago for High Rocks World Championships. And that was my partner today. So I worked a little bit harder than I normally would on a Friday morning, and I'm paying for it severely.
Yeah.
But
yeah. So my arthritis is a blessing and a curse because I can't run. My morning routine is how do I feel? Do I need painkillers to even get out of bed? Yes or no? No? Okay, perfect. Everything hurts, but I can walk. Then I go to my the stationary bike. What do you call it? Yeah. And then I warm up for 20 minutes to get.
We have a phrase in the therapy world: is motion is lotion.
Yeah.
It's you hurt, and then like I did a video the other day. Sorry to promote myself, but on things that we blame on aging that aren't aging, and one of them is stiffness. It's like, well, you've been in the same position when you sleep for 6 to 8 hours, and you will be in pain. And then as you start to move and loosen up, it doesn't hurt as much. It's not to say your condition goes away. It's just more tolerable.
Yeah. And as my physical therapist say, you have to work through a 5.
Yeah, I'm always at like a 4.
Yeah, that's the pain scale, because as long as I work through the 5, it gets my joints loosen up. But I have to endure the pain of getting started, and that is every morning. And then I have to walk out and tend the fucking farm. What? Sorry.
I do the move back and forth, all my joints, mobility in all my joints before I even get out of bed, because I never know what that day is going to bring. Yeah. So I'm right there with you.
Yeah. And then you have all the things I do before I step out of bed. I have that. Okay. Hips up, kick. Hips up, kick. You know what I mean?
Yep.
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 Get
Tomorrow's
everything.
Workout. Oh my God. 4th of July workout. 1776 meter row into 250 double unders. This is partner. 7 rounds of 7 barbell thrusters and 12 pull-ups or ring rows and a 26 calorie bike. Then a 250 meter partner barbell farmer's carry. That just sounds like it's going to suck. But, you know, that's what we're here for.
And he's so uber healthy. He's going to die of dehydration on a mountain somewhere before 50.
Yeah.
While we sit here in pain going, yay, let's have a drink. Now, I do not wish that person death. No, absolutely not. But it's not unheard of that uber healthy people sometimes are too healthy.
Okay, so the court will take care of that. We've got access to the master mailing list of creditors, and so the court will go ahead and notice out that hearing. Ms. Jaimo, I saw that you had continued the 341 to July 16th. I don't think that gives us enough time, because this is, if I recall correctly, a 21-day required notice. Just a second.
That's not me typing, by the way.
Oh, sorry, that's me.
No, okay.
Federal Rule of Bankruptcy Procedure 2002. It's a 21-day notice. So let me turn to Ms. Hall and ask for a hearing date and time, please. Enough for the court to utilize the BNC.
Yes, Judge, that will be Thursday, August 6th at 2:30 p.m.
So that's Thursday, August 6th at 2:30 p.m. Any questions or concerns from you, Ms. Naylor or Mr. Owens?
Well, I'm a little bit confused. So I have to send out the notice of dismissal, or what?
So the court will do that for you. The court will
Okay.
send out, it's highly unusual in a Chapter 11 situation. Generally, the debtor or debtor's counsel sends out the notice of hearing. The court will do that. The court has set the hearing date for August 6th at 2:30 p.m. The court will send out.
Yeah, the judge is fed up. Nah, because you don't do anything, you don't have to do anything. The court will send out the notices for you. And Jan goes, oh, shit. But then again, they are still living in their house. I mean, it's now July. The foreclosure was, I want to say March.
Feels like it was a long time ago.
Yeah. And then they filed, May. No. Either way, they bought themselves a couple of months and will buy themselves another month with this continuance because they keep stalling. And so again, like Laura, they are using lawfare.
It drives me nuts.
Meanwhile, they are racking up debt. I mean, their house is valued at 1.7, but they have debt in excess of 2.3.
And
so
like, maybe it's me growing up, like, not broke, but like damn near broke. That I just don't understand the not living within your means. Even if your means is like $15,000, $20,000 a month, higher than mine. I just don't my brain can't process that. Like Voldemort made fun of me for having a small house. It's like, well, at least I can pay my mortgage.
Yeah, exactly.
Like,
and I mean, I have a decent plot of land and everything, but we are 3 people who are on the owner's deed here. It's my cousins and me. So it's 46 American acres, and then 220 square meter house. See, that is 2,400 square feet. And we have tenants in the part of the house I don't live in. And then the barn on top of that, which is like 5-6 times the size of the house. So yeah, but it is within my means because I worked my ass off to get here. I haven't had, besides mortgage and loans, I haven't had a debt since I was in my 20s. And that's a fucking long time ago. Now I got depressed. Let's spin the wheel.
and after you spin this wheel and I see what you get, I have to get going.
Oh, it's the wheel of abandonment. Oh, look at that.
Oh, poor you.
This is not regrets. This is
poor you.
Old smoky, salty caramel. This shit's dangerous. I mean, a glass, a couple of ice cubes, you don't sense the alcohol in it. Oh. And in my Georgia shot glass.
Moving up in the world.
And that is the final one for the 50 gifted memberships. Now, if you want to spin the wheel, or if you want to make me spin the wheel, let's see, it was gifted 50, which is roughly 3 spins on the wheel of regrets. She gifted 50
Okay.
memberships
Help pay for
at
that
the
trip
beginning
to the
beginning
US.
of the stream. I'm still eternally grateful for that. Thank you so much. So if you want to make me spin the wheel of regrets, it is a combined $50 in supers, gifted memberships, PayPal, or buy me a coffee. Or if you sponsor me with 50 yourself, you choose my poison. And I will show you the bottles I have around. I mean, you already saw the salty caramel. You saw the For Pete's Sake. I also have Penelope straight bourbon, which is also one of these nice. But if you want to punish, behind me here, I have, for example, I have Canadian whiskey in a plastic bottle and an alcoholic proof cork. So you don't lose the cork. So that's one thing. I also have here around here somewhere. Oh yeah, I have Red Hat tequila. I have Finnish whiskey.
That sounds interesting.
I have salty licorice shot.
Oh, that gave me like the ick.
I also have nice tequila, Gonzalez Blanco. So yeah, and I have gin somewhere and stuff and everything. So yeah, there's, and also I have my collection of hot sauces, including.
I keep mine on my desk. I have yet to have anybody super chat me enough money to actually take a drink of it.
Oh, no.
But ghostly garlic, ghost pepper hot sauce stays right there.
So there's plenty. Okay.
Small Bear, I might be 40 and you're 46, but I've also been through, like, I have vet knees, I had brain surgery, so I got a lot of crap going on with that. Like, I got stuff. So 40 is the intermittent check engine light. 45 is when it stays on permanently. I have a metal plate in the back of my head. Like, we're like this. We have a metal plate right there. So we have some stuff going on. The brain isn't exactly all there. It was too big to fit in my head, so they took a piece of my skull and never put it back.
Oh.
Yeah.
So you're an android.
Oh, yes. I don't wear headbands, though, because my head is flat. So
when anyway, they dig us up in 1,000 years, they will wonder about, that's an unusual accumulation of alcohol in this body. And metal lady?
Yeah, I don't set off alarms. I think it's titanium. It's medical grade. But I don't set off, like, alarms or, like, the regular metal detectors. But when I go through TSA, they got something to say. They always got something to say. They're like, is there something in your shirt? I'm like, that's not my shirt. That's my head. Thank you. But I do have to get going. Thanks for having me on.
Thank you so much for being here. And if you find a time later and I'm still on.
If you're still on, I will. If I can sober up a little bit. Like, I even stole the dude's vape because I'm like, yeah. All right. Have a great day. Thanks, guys.
Have a good one. See ya.
Bye.
Bye. All right. Let's continue with this.
Out the notice for creditors and parties in interest who might wish to attend. Within that notice, we'll also be advising folks if and when they'd like to file an objection when that's due. And this will give Ms. Jaimo an opportunity to receive the papers that the court has directed you to give to her in connection with the IDI and the 341. I'm not going to hold those deadlines in abeyance. You were previously ordered to provide them. You haven't provided them. From where the court sits, you're currently in contempt, ma'am.
Oh, she's currently in contempt for not providing the documents needed. Yeah, because if you represent yourself, you're held to the same standards as if you had representation. You are supposed to be knowledgeable about the things you do. Ooh, yeah. Ooh.
Oh, I understand. Okay.
Okay.
Really? I don't
Any
think
other
we
questions
do.
or concerns, Ms. Naylor or Mr. Owens?
None for me.
Okay, thank you. Ms. Jimo, anything further? I'm sorry, Ms. Naylor, did you have a question?
Well, the foreclosure date has been set for July the 28th, and I have filed some objections with the lender, to the mortgage lender, to see what can, and I would like to hire an attorney to handle the foreclosure. So I'm just wondering about how those dates coincide. My hope was to retain outside legal counsel to resolve the debts with the mortgage lender and also the unsecured creditors outside of Chapter 11. So that was what I had hoped to do before July 28th. So with this date being set of August the 6th, I'm a little unclear about the overlapping.
I don't really understand your question. I mean, the court has set a hearing on August 6th, and you said you have a foreclosure on July 28th. So
Yes.
I bet I don't understand what your question is. You stated facts, but what is the question?
The question is, if the hearing is set on August the 6th, how does that impact foreclosure on the 28th? Because there's no, we had asked if the stay could be continued.
I see what you're asking is if the court would be inclined to extend the stay that's temporarily in place.
Correct.
Is that what you're asking? Okay.
Correct. Just
Jimo,
to allow us to sort through all of this.
Ms. Jimo, do you have an opinion?
Yes, Your Honor. The U.S. trustee objects to the extension of the stay. I mean, this is precisely one of the reasons that the U.S. trustee considered the case to be filed in bad faith and an abuse of the system. I believe that the debtors have not paid their mortgage to the tune of $191,000 of arrearages. And while they're seeking the benefit of the stay, they haven't complied with the obligations of the bankruptcy court to justify getting the benefit of the stay.
All right. Do you wish to respond, Ms. Naylor or Mr. Owens?
Well, we have filed letters with the mortgage holder. We believe that there are very, very serious issues that the mortgage holder needs to address with regard to this, and we've filed lengthy letters with them and are waiting to hear back. We've been told that we will get a response, so we're kind of waiting to hear back as to what will happen there.
Did you file this with the court that you had done this? I'm guessing fuck no.
Okay. Well, there's two things in play here. Number one, if you have issues with a mortgage holder and you are making claims or assertions to them or about them, that's completely separate and distinct. That's not occurring in this court. So there's really nothing that this court can do to help you with those transactions with your mortgage lender. And I think you're communicating directly with them, so I believe you understand that.
I'm not sure we are communicating directly with them. I mean, it's been very, very difficult to get to the people that we really need to get to. That's been one of the issues. There seem to be a lot of folks at play here. We get told one thing by people that we have spoken to on the phone with the mortgage servicer, and we get the very next day we get a letter in the mail saying you have options, we can modify things. So it's been very.
Did you file this with the court? No, you didn't. Because hire a lawyer unless you're trying to fraudulently stay in your house despite being way over your ass in debt.
Very much up in the air. We get a bill that says that the monthly mortgage is due, and then we get another thing in the mail saying that all of the arrears need to be dealt with. So we really have been trying very, very hard for a long time to get this resolved and to get something in place so that we can move our lives forward. And as I say, we have uncovered things that we feel are violations that really need to be addressed before a foreclosure could take place.
To the extent that you have claims or issues with the mortgage holder or the servicer, and I know sometimes it's difficult to understand, who to speak with, in particular
Right.
when servicing is transferred, it can be a bit of a challenge. But it sounds like those are issues that you have to take up directly with them. There's nothing pending before this court. This court can only rule on and consider the matters that are directly in front of it by motion or otherwise. So I can't really speak to that situation. And to the extent you want to assert claims, those are generally the types of claims that are asserted in federal court, outside bankruptcy, at the federal district court, or at state court, or injunctions are obtained in state court before foreclosure. So I can't really speak to your situation with your mortgage servicer. I think you'll have to continue to deal with that and find a way to connect with the appropriate individuals or to assert those claims in a proper forum. This is generally not that forum in bankruptcy court. So I'll answer you that. With respect to the pendency of the automatic stay, I have to agree with Ms. Damo that at this time, there's no basis upon which this court should continue to extend the automatic stay. It, by operation of law, should have expired on or about June 22nd or June 23rd. The court did take the extraordinary step of looking at Bankruptcy Code Section 105 and to temporarily extend that stay so that you could perfect the papers that you've already filed with the court and participate in your 341 and participate with the initial debtor interview. And unfortunately, those things have not occurred. The papers have not been amended. The U.S. trustee has not received information for the IDI, the initial debtor interview, or the 341. And so this court can no longer continue to extend the automatic stay. So to the extent that your motion to dismiss asks this court to hold deadlines in advance, the court declines to do so. And again, that motion is not technically before the court anyway. But at this time, during this hearing, which was set on a status hearing for your motion to extend the stay, the court's going to deny that requested relief. I cannot find on this record that there has been clear and convincing evidence, which is the standard, but I cannot find that there's clear and convincing evidence of a change in circumstances between the dismissal of the Chapter 13 case and the filing of the Chapter 11 case for the reasons that we discussed at the prior hearing. So that is the order of the court. I will put that in the minute entry, which will be signed and circulated, and the court will also undertake the noticing of the motion to dismiss. And if there's Ms. Jamo, so what I guess what the court would be noticing out is the motion as filed. And then if the parties want to work out the terms of their written stipulation, then that can be presented at the hearing. Sometimes that itself is noticed out, but it doesn't sound like you're ready to have that noticed out. Is that fair?
That's fair. Yes.
Okay.
Yes, I think that the best thing to do at this point is just to have the motion to dismiss noticed out, see what kind of response, if any, what responses are filed. And then also in the meantime, I can better evaluate what our position should be in light of the documents I'll be receiving and the testimony we'll be getting at the 341.
Okay. All right. Fair enough. Well, I think that concludes all business on the court's docket here today. We've set a hearing on the motion to dismiss on Thursday, August 6th at 2:30 p.m., which the court will notice out. And that notice will be given to all creditors listed on the debtor's master mailing list, and we'll take that issue up then. With that, I'll ask one more time if there's any questions or concerns. Ms. Jaimo?
Yes, just one thing, Your Honor. I just want to clarify for the record the deadline by which the debtors need to provide our office with the number one, the accounting of all the GoFundMe funds, and two, all of the documents that they already are on notice of being required to produce as part of the initial debtor interview. May I suggest that the deadline be set no later than Friday, July 10th, because that gives me sufficient opportunity to review the documents before the 341 meeting.
So that is, I was just going to look at a calendar. That is a week from this Friday, which seems like it should be a sufficient amount of time. So Ms. Naylor, I'm inclined to embrace Ms. Jamo's suggestion of Friday, July 10th to provide the documentation. Okay.
Oh, yeah.
Okay.
All right. So it's hereby ordered that no later than Friday, July 10, the required documentation for the 341, the initial debtor interview, and the GoFundMe accounting shall be provided to Ms. Jamo's office. We previously discussed that I would like those documents emailed in electronic form to her office, and that will be the order this time. Anything further from the parties?
Yeah. So they had a few days to do this, and then they have until, well, they have a week from now, so to speak. Who here thinks they will produce the things? I don't. Because they really don't want to show anybody, especially in court as a public document, what they actually spent that money on. I would imagine they spent it on Laura. Not medical bills, not mortgage, all on Laura.